we ready? Shannon, you can do the countdown. You have a blue paper to move toward me when you think I should stop or anything.
I'll just gently.
Oh, yeah,
put this
thanks.
on the floor and I'll give you a cue to wrap it up.
Yeah. Or my elbow like this.
Oh, that's right. Anyway, so good morning. I'm Senator Jim Abeler. I want to welcome you. Abigail Simpson was brutally murdered by Terry Ann Sherman in front of a toddler. Christopher Dwayne Rice murdered Paul Pfeiffer with a car. Malcolm Leslie shot Tommy McCoy on a bus. What do those have in common? All three of the individuals who committed those murders had been arrested on a charge of some gravity and been released because they were incompetent to stand trial. They were not able to participate in their own defense. And that sounds like, well, we shouldn't be putting people who are incompetent in jail, and we agree. But then we shouldn't be having murders happening either. And so there was a task force, and if you want some really good reading on a Saturday evening, there's two reports from the task force on competency restoration, which is how do we restore people to competency so they can face trial and then be accountable for their actions. And there was that work done. The county attorneys did some of their own work. And to me, it is frightening to think of who is at large in our community. The Department of Human Services at one time would put these people into the Anoka Metro Regional Treatment Center across from my house and restore them to competency, and then they would go and face their trial, and whatever the courts would decide would be their disposition. At the end of 2018, for cost reasons and capacity problems, that was stopped. DHS really did not actually have the statutory duty to deal with that. And in so doing, they, over the time, there's 696 people at that time who were in the situation where they had some serious crime and they were incompetent to stand trial. And so not to worry, 201 were in jail, but 52 were in their own home and foster care and around town, and who knows where they are. And currently, not being tracked very well, and so they could be anywhere. And so what do we do? This is I have to admit, I only became aware of this problem even though I was the chairman back in July or so. And it's the kind of topic, once you discover that it exists, one has to do something. And so come to find out there's been a lot of activity about how to resolve this. And today is the first hearing in the Senate on this topic, and we're going to be hearing both the bill from the task force as well as the bill from the county attorneys. And our intention is to eventually merge those together and come up with a solution where people are safe, but also the person who's incompetent to defend themselves is not a danger to himself or herself and to the community. And so there's a balance, because we do believe in process. Due process is a constitutional right. But what happens when that due process stands on the right of people to not be murdered? So this is more and more complex the longer it gets, but I am so pleased to be joined by my good colleagues. Senator Carla Begum is my lead co-author on this, and I'd like to introduce her.
Thank you, Senator Abeler. First and foremost, our sympathies to the victims that have been tragically murdered from this. This is horrific and needs to be fixed. And I also want to thank Care 11 Investigative Unit for their story on this, to bring an attention to policymakers to make these changes and to close this gap. I will say this, that we need to also have an understanding that there is a complete shortage of mental health beds in this state, and that plays a very large contributing factor to this. But the other large factor is public safety, and that has to be addressed in any fix in this bill. And those that have been around a while know that counties are front and center in the line of work that and will be part of the solution to closing this gap. And I obviously prioritize counties' profusely because they are the worker bees in the administrative level of government. So my goal is to make sure that they are partners in this, whether that's the county attorneys, whether that's community corrections, but that there's ample funding to go with it and direction and expectations. So I look forward to continuing these discussions and appreciate the opportunity to be here. Thank you, Senator Abeler.
And now we'll hear from the county attorneys, and then after that, we'll hear from Senator Housley about some other work she's doing on this very topic. So I'll let them introduce themselves and thank them for being here today.
Thank you, Senators. My name is Mark Metz. I'm the Carver County Attorney, and I'm the president of the Minnesota County Attorneys Association. I want to thank Senator Abeler for championing this legislation, along with his colleagues, and for standing side by side with prosecutors to better support individuals with mental illness and to protect public safety. The Minnesota County Attorneys Association created a committee back in 2017 to address deficiencies in the current system of treating defendants who have been found incompetent. And these circumstances are referred to as gap cases. The current system is a combination of a criminal rule, which lacks statutory authority, and the Minnesota Treatment and Commitment Act, which is designed to support individuals with mental illness. This has resulted in the dismissal of criminal proceedings upon a finding of incompetence without providing services to the individual to help restore them to competence. And very frequently, this has resulted in individuals committing further crimes. So the work of that committee and the Minnesota County Attorneys Association, participation in the Competency Restoration Task Force is the basis of the recommendations found in SF 3728, chief authored by Senator Abeler and co-sponsored by Senator Bigham and Senator Housley. This bill is critically important to pass. The Minnesota County Attorneys Association is ready to do all we can to ensure that this bill becomes law. I will now turn it over to my colleague, Janet Ryder, to talk more about the specifics of the bill. Thank you.
Good morning. I'm Janet Ryder. I'm the Chisago County Attorney and former or immediate past president of Minnesota County Attorneys Association. I just want to flag some of the key public safety components of the legislation that's being proposed. First, the proposed legislation is designed to eliminate gap cases by establishing a direct transition or placement from criminal court into a treatment program or services to restore competence. This clarifies the criminal court has the jurisdiction and authority for placement, which eliminates miscommunication and confusion between those two systems, the criminal justice system and the mental health treatment system. Second, this bill creates forensic navigator positions, a neutral mental health professional responsible for making recommendations to the court regarding the most appropriate treatment options for individuals charged with a crime. These professionals will also assist the individual with navigating the treatment services and complying with the court process. Third, the bill includes some important provisions governing when individuals are out of custody pending a competency evaluation. The criminal court will impose conditions of release and order supervision in the community of these individuals for the purpose of protecting public safety. Fourth, there are some provisions that provide exceptions for targeted misdemeanors, including but not limited to domestic violence, DWIs, and other individuals who are experiencing excessive recurring incidents of misconduct. This bill eliminates the automatic dismissal of these seemingly low-level offenses. Finally, at today's hearing, you will also hear and see a proposed amendment to add an important task force to address juveniles and their issues regarding competency restoration. We have all heard about the uptick in these offenses, and these cases should not be left behind. Thank you. I'll turn things over to Senator Housley.
Thank you, Senator Karen Housley, represents Stillwater and Forest Lake. And yes, I'm going to have the amendment for the Juvenile Task Force this afternoon. The proposed legislation we are talking about today for adults creates a clear process. A statute for juveniles or adding juveniles would create consistency in how the system treats incompetent juveniles. Juveniles who are going through stages of brain development are much more likely to be found incompetent and be released. Some juveniles are still committing serious crimes, as we have seen with so many of the recent carjacking cases. Juvenile statutes are more geared towards rehabilitation than adult correction systems, and we don't want to overlap services, nor do we want to make sure children are falling through the cracks, but different considerations needed than for adults. Legislation resulting from this task force will provide a process for juveniles, reduce impact on child protection departments who are now tasked with providing support, treatment for juveniles. Everyone involved in these conversations agrees that this needs to be looked at, but it was not a charge of the initial task force, so it will be incorporated in today's hearing. Thank you.
Well, thank you very much. And this could be a very long meeting talking about all the nuances, but just to summarize how I see this, you've got the humanity and the people that commit these crimes have a past and there's stuff. You got the humanity, you have public safety. We hope to bridge that so that, how many of these folks can we help to be, restored to being good citizens, and we need good citizens. We also need to feel safe on our buses and in our homes from individuals who are not competent to judge that it's a problem. So, a marriage. So stay tuned. At 1 o'clock today, there's a hearing on this. Both these bills will be here. Michelle Simpson, the mother of Abigail Simpson, will be testifying. And then we'll be going into much more detail on the rest of this. Also in the House, I believe today, they're taking up both these bills. And the authors there are also bipartisan. Senator Representative Edelson and Representative Albright. So we really need to get after this, and this is our move to do our part in the Senate. Stand for questions.
When I looked at this legislation, it looks like a really key component is that judges will be able to maintain control of these cases and even have probation officers, in theory, overseeing folks while these cases remain in this limbo because they're incompetent. Is that correct? And how important distinction is that to have the courts maintain a level of control? Because when we talk with judges, we're hearing, we don't even know if we can do that.
This proposed legislation does address that issue. Currently, when a person is found incompetent to stand trial, the matter is referred to our local social service agencies, our health and human services professionals who have a different standard, they're looking at different factors. It's a separation of powers issue in that our judicial system does not have authority or control over our local social service agencies in that capacity within the realm of the criminal justice system. They do under the Treatment Court Act, but it's that inconsistency, that incongruence between those two systems that creates the problem, and this legislation is designed to address that.
And you also mentioned, Mr. Ryder, about direct placement from criminal court. When there's already not enough beds, how does that work?
There's two things. Certainly, we hope that this legislation will promote and prompt our cohorts in this system to create more beds to serve these people. That is first and foremost. However, secondly, many of these people may be able to be treated in the community, and that's where our court services, probation, those staff would be, and these navigators would be able to monitor these people in the community. Currently, there are some cases when a person is found incompetent to stand trial, the court loses jurisdiction over these individuals. That is the problem. That is a significant problem that allows these people to go unchecked, unmonitored, and creates that public safety issue that we're concerned about.
So within the bill, there is no funding to increase mental health beds. That would be a separate issue. So, you want to rely more perhaps on mental health beds for treatment, of which there is a shortage, but there isn't necessarily the funding mechanism to ensure that there are those beds available?
That's correct. There is an amendment coming which will add some money to the counties for probations and other several $1 million, and there's an amendment. So we are trying to address the existing county infrastructure. Currently, the counties are responsible for the oversight after they get the handoff from DHS. But I will tell you that people in their homes want to feel safe. And just because it's complicated or challenging is not a reason to act on this. And so we don't want to overload all the state beds, but at the same time, we have to help people to be in a place where we're safe and where they're getting what they need. So that'll be discussed.
We do have a hearing on 2 bills to address this week as well. Senator Rosen has a hearing for adult mental health beds, and Senator Drahan has a bill for a pediatric mental health bed. So it would be separate, but we are actually moving on that too.
Yeah, good point.
Is there any concern from the counties that this becomes an unfunded mandate of sorts that just kind of gets softball?
Yeah, no, AJ, exactly, that is a concern, and I appreciate the foresight and Senator Abeler being proactive and reaching out to me to be a partner on this side of it, because we don't want that. We want them to be partners and good partners, which they always are, but they need the money to do this. They can't just be forced to do something. This is really going to be a team effort. And again, it is about the safe communities. It is about giving guidance and transparency and expectations on how we close this gap. And so I'm confident that we will have money in the bill that will help make sure it's not an unfunded mandate. We are adding an amendment in committee that will address this, and I consider that a placeholder. So it's only going to go up in my mind. And so once we hear the testimony, hear from the county attorneys, hear from the county commissioners and the community corrections folks, I think we'll get a better idea of the actual amount, though.
Just one final thought. If we accomplish anything yet this year, I hope we can make a good stab at it and even maybe get this resolved. But people wonder, what can the legislature ever figure out? Actually, once we put our collective minds to it, getting away from the politics, getting away from any personal thoughts, and how do we solve some complex issues, we really have a lot of expertise. Case in point, who's standing behind me, who's standing at my sides, who will be at the hearing today, finding a way to first identify what we need to do. At this point, most people have never heard of this topic, and they don't even know the challenges that exist on their own safety and the rest. And so if we can define what's the best way to resolve this, how to get rid of the cross-jurisdictional challenges where everybody's business is nobody's business, that's what we have today. So we have to decide whose business is it, and then how are we going to make sure that the system actually works with due process and safety, both.
I had one question for Eddie. I sent you a little bit of information yesterday. We recently had a case here in St. Paul. A man breaks into a home and rapes a 14-year-old girl. Looking back at his history, he is one of these gap cases. In Carver County in 2019, he's caught with a stolen car and a woman who claims he was holding her against her will. That case gets dismissed. In Ramsey County at the same time, there's a car theft and he's broken into a woman's home and says he was thinking about having sex with her. And in that case, it's dismissed and stuff's declined. Fast forward to now. How does this bill better prevent a case like that from happening?
Yeah, what this bill does for a case like that, it fills the gap in the sense that the court has authority over this individual to place them in a facility where they can be treated to competency, where they can get the proper treatment to restore them to either be tried or to live in the community. And it also gives options for the court to set conditions of that release instead of putting county attorneys in a situation where an individual is found to be incompetent and we have to dismiss the case. And so this will take care of that issue in large part because the court will have that authority under those circumstances. And I think of it's like an analogy to when somebody goes to prison and they serve 2/3 of their time and then they're on supervised release under the Department of Corrections. So the Department of Corrections is monitoring them. They're ensuring that they're being treated, they're following their conditions, that the public is safe. And here we have this gap where we're trying to help this individual who committed a crime to restore them to competency, to eventually get them so they can live in society, but they're not being properly monitored because the courts don't have authority, the jurisdictional issues that we have. So this is critically important to, as the senator indicated, to blend these to public safety, which is a priority, but also to restore them to competency, because these individuals are going to get out and they're going to live in the community. So we have to treat them. And that's going to take a lot of resources and skill and experiences, and we have to come together for this, because we can't have individuals that aren't getting treated and they're back out there to reoffend.
Thank you.
Right.
Thank you.